Good day, ladies and gentlemen. Welcome back to another episode of What If. I am VP Moolman from Maserumule Corporate Employment Law, and in this episode I will be discussing what if an employer monitors and intercepts employee communication in the workplace. Now, we know that employers often monitor employee communications, for example, email, websites visited, and telephone calls made. And this is done generally to gather evidence required to take disciplinary action against the employee. But employers also sometimes monitor communications to comply with regulatory requirements. And therefore, it is critical for us to discuss and unpack how employers can lawfully monitor employee communications. Now, the law dealing with the monitoring and interception of communications is the Regulation of Interception of Communications and Provision of Communication-Related Information Act, also known as RICA. Now, RICA came into effect on 30 September 2005, and it highlights pertinent issues on monitoring and intercepting employee emails, telephonic discussions, and other communications. Importantly is that RICA places a general prohibition on intercepting any communication in the course of its occurrence or transmission. But what does interception and what does communication actually mean? So in terms of the Act, interception of communication means the acquisition of the contents of any communication so as to make it available to a person other than the sender or intended recipient. Interception also includes monitoring, inspection of the contents, and diversion thereof to any other destination. What does communication mean? Communication includes direct and indirect communication. Indirect communication specifically refers to the transfer of information in the form of, for example, speech, data, text, visual images, signals, and music or other sounds. In the work environment, the interception of email messages, telephone calls, and text messages are consequently specifically included in the general prohibition on the interception of communication. But what is important to note is that provision is made for several exceptions to this general prohibition. One of these exceptions is contained in Section 5 of the Act, which states that any person may intercept communication if one of the parties to the communication has given prior written consent to such interception, unless such communication is intercepted by such a person for purposes of committing an offence. Now, Section 6 of the Act provides for a further exception on this general prohibition. In terms of Section 6, any person may, in the course of carrying on of business, intercept any indirect communication that relates to that business in the course of transmission thereof. More specifically, the section concerned requires that interception may only occur if it has been consented to by the system controller, generally the employer, or if it is done in order to establish the existence of facts or to investigate the unauthorized use of the system, or where it is undertaken in order to secure the effective operation of the system. Furthermore, the telecommunication system must be provided for use in connection with that business, and the system controller must have made all reasonable efforts to inform in advance a person who intends to use the system that communications may be intercepted with the express or implied consent of the person who uses that system. Now, some employers and employees are of the view that employers at all times need the written consent of employees to monitor and intercept email communications. Now, this debate centers on the interpretation of the two sections that I've just referred to. And as we've mentioned, in terms of Section 5, any person, including an employer, may intercept communication of one of the parties to the communication if that party has given his or her prior consent. This does not, however, mean that this is the only way in which an employer may intercept indirect communication. Section 6 has a more specific application, and as we've mentioned, it states that any person in the course of operation or operating any business may intercept any indirect communication if the above requirements are met. So the debate specifically revolves around whether an employer is entitled to intercept an employee's indirect communications without obtaining the employee's prior written consent. Now, a careful reading of the sections in question should serve to dispel most fears as the requirement for consent to be in writing is contained only in Section 5 of the Act, which section is not directly applicable to the interception of communications in connection with carrying on of a business. The latter, as mentioned, is governed by Section 6 of the Act, which section does not contain a provision that such consent need to be in writing. Accordingly, express or implied consent is merely one of the ways in which an employer could meet the requirements of Section 6 of the Act. As we've pointed out, Section 6 also provides for permission to intercept indirect communication if the employer has made all reasonable efforts to inform in advance a person who intends to use the telecommunication system concerned that indirect communication transmitted by means thereof may be intercepted with the express or implied consent of that person who uses that telecommunication system. So it should be evident that an employer may intercept an employee's indirect communication where the employer, firstly, makes all reasonable efforts to inform the employee in advance of the employee using the communication system that the employee's indirect communications may be intercepted, or two, obtain the employee's express consent to the interception of indirect communication, or number three, obtains the employee's implied consent to such interception. Now, the requirements of making reasonable efforts or obtaining express or implied consent presuppose the need for business to ensure that the technical or other solutions they choose to implement indeed comply with the legal requirements in question. The requirements of reasonable effort indicates the need for businesses to ensure that a proper and extensive internal IT or information technology user policy is in place. In the case of implied consent, an employee could, for example, electronically sign an agreement in terms of which he or she will be deemed to have consented to the interception by clicking on the, as we know, I accept button at the time of logging onto the company's network. Now, when an employer obtains an employee's prior written consent, the employer would, it seems at least, be informing the employee in advance that the employee's indirect communications might be intercepted and that it is the intention to do so, or it's the employer's intention to do so. The Act does, however, not require employers to go to these lengths, and it's obviously the safest option to obtain an employee's prior written consent. As such, an employee would not be able to argue that he or she was not aware or did not consent to his or her indirect communications being intercepted. A further aspect to keep in mind is how and when the employer may gain access to an email message, for example, that have already been transmitted between two parties and that is stored on the recipient's system. In such a case, where transmission has already occurred, interception according to the Act can no longer be affected and the provisions of the Act are no longer applicable. This does not necessarily grant employers free access to employees' computers or computer where the email is stored. Employers would have to make provision for legal access in this regard, and aspects such as privacy rights. We know that the POPI Act, so aspects such as privacy rights need to be regulated in internal policies or employment contracts. The most appropriate step to be taken by employers to ensure compliance with the Act will depend on the content of each employer's existing employment contract, email policy, and the degree to which email facilities are made available to its employees and for which purposes such facilities are made available. It should, however, be remembered that an employee who has internet access may damage the business in other ways. An employee could, for example, waste time on the internet or overload the office network with private material. Abuse of this sort can often be detected by observing network traffic, and it's not necessary to know the content of or intercept communications when observation takes place. Employees may still object to observation, but it's easier to justify monitoring traffic than intercepting communication. Observing traffic can also point to possible cases of serious abuse. This could in turn justify intercepting communication. So, in conclusion, intercepting communication, observing communication traffic, and the appropriate use of office communication tools should be dealt with in appropriate and well-drafted policies. Perhaps this is the opportunity for you to revisit your policies if you have it in place and ensure it is aligned. So, ladies and gentlemen, that then brings us to the end of this episode. Should you require any assistance in this regard or in regards to this topic, please do not hesitate to contact us. And please remember to head over to our YouTube channel and kindly click the like and subscribe button. That will be appreciated. We look forward to you joining us for our next episode. Bye-bye.